Yes, Mr. LaVergne, is there a quiet?
Can I stand for this one?
Excuse me, you don't have to stand.
May I stand?
Oh, you may stand, yes.
There are three things I need to address. First is standing. You are mentioned that I'm obtaining pollution of that. That's not correct. I'm arguing against the option. I want a fair and honest ballot. The gentleman's petition was submitted that was not challenged in the 4-day window. He belongs on the ballot. He's my opponent. This is not something that benefits me. But his right to be on the ballot is part of a fair and impartial ballot process, and that's what I'm going to defend. Second, Mr. Fortune and I, and other independents that are on the ballot in other elections in this state enjoy the same 4-day exposure to challenge that the Democrats and Republicans enjoyed the challenge back in March. That 4 days, instead of starting on Monday, because the statute says clearly that the primary petitions are for 64 days before the primary election. No matter how you do the math, it's like 64 days, like 7 days in a week. One day left over, those petitions should be put on Monday. And as the folks at 225 State will tell you, 4 o'clock on Monday every year on that day, I log into the book because anybody that signs in after me is out of time. I've done it for years. Now, that said, if 4 days from Monday is Friday, 4 days from Tuesday is always Saturday. Whether we agree or disagree, the challenges could be emailed, faxed, or sent by carrier pigeon is irrelevant in this matter, because nothing was filed before midnight on Saturday. Nothing was filed before midnight on Saturday. Now, what Mr. Cohen believes as far as going to the appellate division, Mr. Dono believes as far as her interpretation of the ruling, or what the judge's ruling was, or even what was on Mr. Fortune's ballot petitions. The fact that the calendar that's on the internet was incorrect is not any issue that neither Mr. Fortune or I should be penalized for, any more than it would be an issue if, when reviewing ballot petitions, we would find that the state of New Jersey's website in describing District 33 leaves out the towns of Groveland, Florence, and Fieldsboro because they were in the prior portion. So if one were to go to the internet and look up not only the calendar, but the actual content of District 3, it's conceivable that ballots that were signed that are from those particular communities might be rejected if we relied on the internet's position. Okay? If Mr. Fortune turned in a petition, the Board of Elections accepted, and it was not rejected by them on Tuesday, June 3rd, and no challenge was raised before Saturday, and I don't care if it's 11:59:59, as Mr. Frederick may have said, okay, at midnight, Mr. Frederick, your objection is turned into a comment. Sorry, there was no challenge. Any proceeding Mr. Donald spent the state's money on was a waste of our time, our assets, and the fact that I had to be before this court, waste this court's time on a matter that should have been thrown out last week is a shame as well. Your Honor called us under the statute to appear within 3 days of our trial, and here we are. Your Honor was served our order to show cause on Monday, which technically would have been 1 day at a time, except the statute is very specific that if the last day falls on a Sunday, not a Saturday, on a Sunday, then it washes into the next day. So the statute is specific on carryover for the day of Sunday, but specifically does not include Saturday as carrying over to Monday. So if you're going to contend that you can fax a challenge, I'm pretty sure that even though the building is closed, your phone still works and your fax machine still works on Saturday. And you got a timestamp form that says so. I do have a question, Your Honor, that I'd like to have something read back that was said earlier too with the LaVergne. If I could ask the indulgence of the court.
That's refused.
All right.
Thank you. Mr. Bono, you didn't file any papers. I got a notice of appearance, I think, yesterday. I'm not even sure if it was filed in the proper way, but it's a 3-day issue, and you're like,
embraces the electoral process, and if this board or any other board, whatever we deem appropriate, wants them to be on the ballot, then she embraces that and, more to the party. So.
And you are only representing her, and she did not file any challenge to Mr. Fortune's petitions, is that correct?
Correct.
Thank you.
Thank you.
The court wants to thank everyone for turning the, cooperating in presenting the case to the court in this very quick fashion. The court signed the order to show cause in light of NJSA 19:13-12, which noted that the court should make a determination in 3 days after the filing of the application or complaint. I then had the opposition by the Attorney General, which suggests that that section of the statute does not apply to this proceeding, but in any event, I decided to go ahead with the proceeding today in light of the 3 days that were mentioned in that section 12 of the statute, and also because it is an election case, and there is always a time sensitivity with election cases. In this complaint, Mr. Fortune has pled that he was seeking to get ballot access for the general election for the 3rd Congressional District in New Jersey, which covers parts of Burlington and Ocean counties. And the Division of Elections found itself, but it did not note any problem with his petitions. The section 19:13-10 speaks of every petition in apparent conformity with the provisions of this title shall be deemed valid unless objections